Una Platform, sound check, testing. Chairperson's mic, platform, sound check.
We can hear you.
Thank you. Going to another one. Put their microphone sound check. Put their microphone sound check.
Checking sound check 1, 2.
You are audible. Thank you.
Thank you, Putman.
Two.
Recording in progress.
The House Chairperson.
There will now be an opportunity for silent prayer or meditation. Thank you. We may be seated. Order, honorable members. The first item on the order paper is a motion in the name of the Chief Whip of the Majority Party. I will now recognize the Honorable Chief Whip of the Majority Party.
Thank you very much, House Chair, honorable members. Honorable members, I here move that the House must note that Section 24(1), subsection A of the Political Party Funding Act of 2018 requires that President acting on a resolution of the National Assembly may, by proclamation in the Gazette, make a regulation contemplated in Section 6, Section 7, Section 8, Section 9 of the Act. Further notes that Electoral Matters Amendment Act of 2024, which was passed on the 12th of March 2024 and having come into operation on the 8th of May 2024, and the regulations contemplated in Section 24, subsection 1A and of the Act inter alia of Section 8, subsection 2 and 9, Section 9, subsection 1A have to be made by the President acting on a resolution of the National Assembly. Further notes that when making the regulations in terms of Section 24, subsection 1A of the Act, the President must take into account the following factors: the amount of money previously appropriated by the Acts of Parliament for the Political Representative Fund with the previous 5 financial years, the constraints on the fiscus in funding political parties, independent representatives, or independent candidates. The number of political parties represented in Parliament, including the potential number of independent representatives and independent candidates to be represented in the provincial legislatures of Parliament, the effects of inflation on the value of money over time, the need to allow sufficient donations which must be disclosed by parties to political parties, independent representatives, and candidates in order to deepen participatory democracy, the actual fiscal contribution to public funding for political purposes, and the cost associated with participating as a political party, independent representative, or independent candidate in elections and the democratic process in South Africa. Acknowledging that the task of making regulations required time and therefore resolves as follows. The President make regulations regarding the amounts contemplated in Section 8, subsection 2, and Section 9, subsection 1A on urgent basis as set out in the Regulation 7 and 9 of Schedule 2 of the Act. The President must, within 6 months from the date of this resolution, table a comprehensive draft regulation for consideration of the National Assembly and for a resolution to be made in terms of Section 24(1)A of the Act. I hereby move, Honorable House Chair. Thank you.
Thank you very much, Honorable Member. I now put the motions. Are there any objections? Honorable Singh.
Thank you. Thank you very much, Honorable Chairperson. Good morning, colleagues. Honorable Chairperson, I'd like to bring to the attention of the House that this motion was not on the website of Parliament last night, as is normally the case. The order paper of Parliament is always put on a website the evening before. I have only caught sight of this resolution about 30 minutes ago. And on reading the resolution, I'm extremely confused as exactly what is required from us in this House. I discussed it with the Chief Whip of the majority party, and I felt, as we normally do with motions of this sort, we have a discussion amongst the whippery and then bring a motion before the House, that we be given time as the whippery during the session to meet, talk about the contents of this motion, and you place this item as the last item on the order paper for today. And that is my request, Honorable Chairperson. Thank you.
Thank you very much, Honorable Singh. Taking that you are saying the motion was not there by yesterday, I see the hand of the DA, and I'm going to allow, before I resolve on it, all the whips or the chief whips to say something before we proceed on that.
House Chair, thank you very much. I would support Honorable Singh's proposal to at least have a quick discussion during the course of the sitting, and that perhaps this item serves just before the farewell speeches today, and then it can be considered by then, because we just need to understand some of the contents which we did not have sight of before. Thanks.
Thank you. Honorable Swart.
Thank you, House Chair. House Chair, the ACDP understands the importance of this motion and therefore supports the Honorable Singh that it should stand down for us to consult and discuss the implications of it, given that it was circulated very late last night. Thank you very much, House Chair.
Thank you. Any other party? Do we have any hand from the... do we have hands? We don't have hands. So if in that case, Honorable Chief Whip.
Thank you very much, House Chair. House Chair, I don't have any problem as Honorable Chief Whips are recommending that let's have a further consultation on the matter, but it must not be the last item. It must be an item on the order paper before the farewell speeches. So we commit that it will come back here because this is our last sitting and we have to deal with this matter once and for all. Thank you very much.
Thank you. I see that we have the NFP. Do you have any bite? Want to have any bite? No, it's fine. It's fine. Okay. Honorable members, with all the discussions that we just had on this resolution, I will agree that the whips, because we know that we did not have a chief whips forum as our usual way of doing things. So I will allow all the chief whips to meet during the course of the day, and this item will come back in the afternoon. Thank you very much as we proceed to the next one. At this stage, I will ask the secretary to read the first order of the day.
Consideration of Basic Education Laws Amendment Bill and of report of Portfolio Committee on Basic Education thereon.
Thank you. The chairperson of the Committee on Basic Education, Honorable Mpingo Gigaba, will introduce the report.
Asigqibeni le nto. Asigqibeni le nto. Thank you very much, Honorable Chair, Honorable Chief Whip, members of the Progressive Movement, our ANC. The Basic Education Laws Amendment Bill is a critical milestone for the 6th Parliament, for South Africa, and more especially for the education sector. The bill we are considering for adoption after the completion of the legislative process by the National Council of Provinces, which resulted in amendments. Embodying the participatory nature of our democracy, the public hearing in the National Council of Provinces have led to a few critical amendments, a testament for the value we place on public input and the strength it brings to the bill. To highlight the key amendments affected by the National Council of Provinces, the amendments are on the intention that alternatively a court may impose a sentence within the court's discretion as contemplated in terms of the Criminal Procedure Act. This is an amendment which responds to the concerns raised by the public on the prescription by the bill on a period of conviction for a person prohibiting a learner from schooling. The impact of this amendment will enable the judiciary to decide on the sentence based on the fact of those who commit acts that undermine the future of our children and nation. The other key amendment clarifies the role of school governing body and the head of department in relation to the language policy. The amendment emphasizes the authority and role of SGB in determining the school's language policy or any amendment thereof. It strengthens measures to review decisions taken by the head of department by stating that, and I quote, if the governing body is not satisfied within the directive of the head of department as contemplated in Section 7, the governing body may appeal against the directive to the member of the Executive Council within 14 days after receiving the directive. And I close quote, Sanui misreader and misquoted. To give clarity on conditions of a just cause to limit certain clauses in the school policy, the NCOP amended and inserted that it must be account of, but not limited to the following circumstances, that a learner may bring to the attention of the principal of or governing body of the school, the cultural beliefs, religious observances, and medical grounds. It is important to have clear parameters for consideration of deviations. To enhance the protection of right of learners and fair procedures by ensuring that governing body may, on reasonable ground and as precautionary measure, suspend a learner who is suspected or accused of serious misconduct from attending school, but may only enforce such suspension only after the learner has been granted a reasonable opportunity to make presentations to it in relation to such suspension. The amendment also clarifies the act of serious misconduct by the learner on acts which occurs on a school premises or at a school activity, and the learner has been formally charged by South African Police Service. The governing body must suspend such learner immediately without granting the learner an opportunity to make representations in relation to accusation of such serious misconduct. On learner and teacher support material and central procurement, The bill amends the clause to include the authority of the SGB to procure books if it is cost effective. Now, these amendments have been accepted by the Portfolio Committee on Basic Education, IZOL, and we bring this report and final bill to the National Assembly of adoption. You laugh only if you did not agree, but Tina Siyavumas. Thank you very much.
Thank you. May I now recognize the Chief Whip of the Majority Party?
Thank you very much, House Chair. House Chair, I move that this House adopts this report. Thank you.
Thank you very much. As I recognize the parties that wish to make declarations on this report, the DA.
Slalo, yesterday the ANC sacrificed the future of countless generations for cheap electioneering by bulldozing the bill through Parliament. Instead of engaging meaningful discussions about the widespread implications of the bill and the changes made by the National Council of Provinces, the ANC chairperson, who surely doesn't understand the bill, refused to follow parliamentary protocol and denies opposition parties the right to include thorough inputs to the changes. She booted me out of the meeting for raising valid concerns, and the ANC majority adopted the bill full of mistakes without interrogating the final version. It seems the closer it gets to 29 May, the more desperate the ANC is to try and convince the public they've looted and undermined for 30 years that they actually care. But their actions regarding the public participation speak louder than their desperate electioneering attempts. A genuinely caring government would have listened to and addressed the concerns of the public, the majority of whom totally rejected the bill. A caring government would have amended the deeply problematic clauses that continues to disempower schools and communities and stomps on the rights of parents. Instead, the ANC government left a backdoor that still makes it the final authority on language and admissions in schools. While changes have been made by the NCOP at our insistence to problematic clauses regarding admissions and language policies, procurement, and the homeschooling sector, the very real threat of abuse has not been removed from the bill. And the DA has no doubt that the ANC would jump on the first chance they get to impose what many struggled so hard to overthrow, a decentralization of power by the state, similar to a Bantu education style policy that imposed a language of instructions on schools at the detriment of our children's quality education. The last 30 years under ANC governance has seen very little development of indigenous languages. The bill persists of centralizing power in the hands of unelected bureaucrats, undermining the critical role of parents, educators, and the local governing bodies in shaping the educational landscape of their communities. While other successful countries with quality education are decentralizing decision-making to the lowest level of government and communities, the ANC wants to centralize power. The bill now explicitly forces all schools to purchase stationery, textbooks, and other learner support material at a centralized tender system under departmental control. Another scheme designed to let ANC cadres loot while schools suffer. It will result in the late delivery of
Order,
and
don't drown the speaker.
The ANC has no shame to destroy what is left of our public schools. The department's failure to engage with the homeschooling sector on the best means of regulation and the committee's ignoring of public submissions contravenes a constitutional court judgment on the Traditional and Cohesion Leadership Act. The bill still imposes excessive regulatory burdens on parents who opt to homeschool, infringing on their autonomy and freedom of choice. A government that cared about our children would have ensured that they attend schools where they live, where their lives aren't in danger from dangerous pit toilets, asbestos roofs, and that fall on their heads, or unfenced premises. 3 weeks ago, I sadly went to bury 3-year-old Unoxebo Mboteni, who died after drowning at his school's pit toilet. That is why making grade R compulsory should be completely funded and not leave provinces at risk of more atrocities like this. A government that cared about our children would have ensured that they can read for meaning by the age of 10, that they have basic numeracy skills under their belt, and that a matric qualification means that they have the skills that they need to meaningfully participate in the economy without to have been feared of becoming one of the 3.6 million young people not in education, employment, or training. This ANC government did none of these things. After 30 years in power, they continue to undermine the people they meant to serve. The way the ANC ignored parliamentary protocol and legislative master to push the bill through parliament is evidence of the fact that for them, no sacrifice is too precious to retain their power, not even the future of our children. A matric pass rate is so meaningless today that the majority of young people are destined to sit at home with no access to university or job opportunity. You see, the thing is about savers of achievement. They don't care what you say you have done. They just measure what you actually have delivered. And the ANC is shambolic. The bill has become just another tool for South Africans into selling their birthright for a pot of poisoned lentil soup. The DA remains steadfast in opposing the bill, committed to fighting it every step of the way, from Parliament chambers to the President's office, ensuring that our children's futures are unshackled by outdated legislation. The fastest way to stop this ANC bill and ANC destroying our future is to vote them out in the 13 days that are left on the 29th of May.
Thank you very much.
No care of our
Your
children's
time
future.
is up.
Thank you so much.
Thank you. Order. The EFF.
Thank you, Chairperson. We supported the bill when it was tabled in the National Assembly for the first time. After looking at the amendments done by the NCOP now, we are still in support of the bill. We support the amendment of the South African Schools Act, which seeks to make education grade R to grade 12 compulsory, and the criminalization of anyone who blocks children from attending schools without a just cause. We support the provision that gives principals more powers to monitor the attendance of children at school and to take action should there be no indication of where a pupil is after 24 hours of not attending school. This provision is purportedly to curb the high dropout rate at school. Principals and SGBs are given more powers to follow up and find out the reasons why children are out of school. This provision, however, could potentially spread principals too thin. It can't be their sole responsibility to do this. It was primarily for this reason why our manifesto, we advocate that each school must have its own social worker to deal with problems such as this and to understand the social problems that lead to many learners dropping out of school. While provision is progressive in as far as making school attendance compulsory, we must submit that enforcement of this must not be the sole responsibility of principals and SGBs. The department must appoint qualified social workers to deal with issues like this in every school. We are also in support of the powers to be given to heads of departments to make determinations on the language policy of the schools. This function can't be left to the SGBs, as many in the previously white schools still use language to exclude many Black children. This is particularly so in the Western Cape, where Afrikaans is used to exclude African learners. It is particularly this provision that the DA and other right-wing parties hate because it takes away their power to racially exclude learners. We are also not in support of the provision that makes it permissible for children below the prescribed age to be allowed to register to grade R if their HOD concurs. Children must be allowed to develop fully and not be rushed through school grades. Ndabulela, Chairperson.
Thokoza Mhlonishwa. Order. The IFP.
Thank you very much, Honorable Chairperson. As I have previously stated when debating this bill, we cannot throw the baby away with bathwater. When it comes to regulating the basic education system, it is more feasible to try and amend some of the challenges highlighted than it is to completely do away with something that could effect substantial change. As we have seen from deliberations in our committee meetings, there were a number of things we could agree on. The IFP has made no secret of the fact that it takes issue with the bill's approach to the powers of the school governing bodies. The SGBs bring contextual knowledge of the community and the parents' perspective that no other school body that you can think of could possess. Therefore, They are crucial in the functioning of the schools. SGPs are the bridge of communication, linking the needs of the children to the understanding of the school teachers and principals. In rural communities, it is often through the participation of parents on the SGPs that schools learn of the challenges children face in the community that are affecting their behavior in school. We cannot allow schools to be used in any agenda the government tries to push. Therefore, this is very big danger in the assumption that the state will always act with good intent. Therefore, the concentration of powers in only one position, in this case, the HOD, needs to follow the appropriate vetting processes. However, these are challenges that we can collectively work on as part of the new government. It is with this in mind that the IFP Nkatha Freedom Party accepts the report, Chairperson. Thank you very much.
Thank you. The FF Plus?
Thank you, Honorable House Chair. Hierdie aanname wat vandag gemaak word, kan sekerlik uiteindelik een van die ANC se grootste strategiese foute wees. Want hoe langer die openbare deelname gegaan het, hoe minder steun was daar. Hoe langer dit aangegaan het, hoe groter was die teenstand, tot die mate dat die regsadviseur van die parlement gesê het, sy weet nie hoekom nie, want die punte waaroor die mense kla het niks met die Bella te doen nie. Daar's 'n baie goeie antwoord. Dis 'n mosie van wantroue teen die ANC-regering se vermoë om onderwys te bied in Suid-Afrika, en dit het gekom van die eie ondersteuners. Dit het gekom van 80% van die mense wat aan openbare deelname deelgeneem het in die provinsies. En elke keer word daar gesê, kom ons gaan na die townships en die rural areas to hear what the people say. En dan sê die people nee, maar die ANC kan nie luister nie. So daar in 1994 'n lewensmoe en 'n regeringsmoe regering van F.W. de Klerk die magprys gegee het hulle dit reg gekry op grond van twee sake. Hulle het gesê ons het nie groepsregte nodig nie, want ons kry ons groepsregte deur middel van individuele regte. En hulle het gesê gemeenskappe sal die bestuur kry oor hulle eie skole. Dit was eintlik 'n baie swak ooreenkoms van gemeenskappe wat onafhanklike onderwys wil hê, want die regering het die beheer geneem oor die totale inhoud van skool, gemeenskappe net oor die bestuur daarvan. Met ander woorde, met uiters doeltreffende bestuur is ANC propaganda in skole gedoseer vir die afgelope 30 jaar. Maar nou selfs daardie toegewing wil die ANC nou terugtrek. Die ANC het nie nou te doen met die geslag van 94 wat lewensmoeg en regeringsmoeg was nie. Daar het 'n nuwe geslag opgestaan oor die laaste 30 jaar wat moeg is om tweede viool te speel en wat aandring op hulle regte as kultuurgroepe. En daarvoor is artikel 235 deurslaggewend wat gemeenskappe met 'n gemeenskaplike taal en kulturele erfenis die reg gee om instellings van hulle eie tot stand te bring. 'n Voorbeeld daarvan is skole. Wat nou gaan gebeur, is ons gaan doen wat ons nog altyd doen as die staat teen ons draai. Ons los hom eenvoudig uit. Die staatsskole gaan misluk, die mense gaan omdraai en hulle gaan onafhanklike onderwys, tuisonderrig aangryp en die ANC gaan sit met eier op sy gesig. Baie dankie.
Thank you. Honorable members, if you can check these earphones close to you, to just switch them off. They are disturbing, especially this side. There are a lot that are open and unlistened to. The ACDP.
Thank you, House Chair. The ballot vote should be about one thing, and that is learning. It is a powerful personal growth and spiritual principle that how we do something is as important as the outcome we achieve. Die tragedie.
Honorable Sukers, please take your seat. Honorable Mvana, please switch off, mute your mic. Thank you. Proceed, Honorable Sukers.
On translation, Chairperson.
I can't hear you.
I'm saying I had raised my hand earlier on because translation is a bit slow. I hope when Honorable Sukers needs translation will be faster this side.
Okay. Translators are hearing you as we proceed. Thank you. Proceed, Honorable Sukers. I'm sorry for that, but you can see your time is still intact.
Die tragedie van die wetgewing is dat die ANC regering glo nie in die beginsel nie. Dit glo nie in enige beginsel nie. Dit sal enige iets doen om te lyk hulle was hulle gesig. Hulle doen dit nie. Tens of thousands of South Africans came to the public hearings on the billable. Our people came from rural areas and asked for a change to a more practical curriculum. Homeschool moms came with their children around them, quoting international legal treaties. They came and they shared their hearts, their minds, their hopes and dreams and their love and concern for their families and their fellow South Africans. But rather than unite in diversity, you sought to attack and divide. Rather than be open, you sought to hide. Rather than to listen, you sought to silence. When the people said this is an abortion bill, you fell back on verbal threats rather than simply admitting and changing your policy that is currently in play. This country needs a better billable. Honorable Morasetla and I shared in the committee that our children had been discriminated against when trying to get them into good schools. The way that you have passed this bill to say nothing of the secret last-minute attempted half compromises that were made behind the scenes have betrayed our people. It will mean it will be struck down.
Honorable Sukers, I'm sorry, there is a hand. Honorable Abrahams.
Yes, thank you so much, House Chair. Just a point of order, because in this country, there is no abortion.
No, that's not a point of order, please.
Okay.
Thank you. Proceed, ma.
Don't tell me to sit down when
The members will do well to do some reading. Every time you chose not to do better, right up to yesterday morning in the committee, you made this more certain. You were better when you were led by Chief Albert Lutuli. You were better when you were led by Mama Charlotte Mateke. Today, the ACDP pick up the mantle of Christian democracy from both shoulders to ensure our nation is going to be better. The ANC of today is not the ANC of Albert Lutuli. It is not the ANC of Charlotte Mateke. You principles. You abuse our churches. You parade on the platforms. And you lie to our people. Thank you.
Chairperson.
Thank you. Order.
Chairperson.
Okay, sorry.
Chairperson.
Honorable members, there's somebody there.
Chairperson.
Is there a hand there?
Chairperson.
Who's speaking besides Mr. Swartz? Who's speaking? Honorable April, your hand is up.
Thank you very much, Chairperson. It is late now because Honorable Sukers has already left the table, so I will not speak. But she was, we didn't hear anything. So net open screen.
Don't proceed. Honorable Swart?
No, Chairperson, there were a number of gestures that were made, and we know that is unparliamentary as well. That's the first point, I think, by the Chairperson of the committee that spoke earlier. Secondly, the volume. One, as you know, Chairperson, there are interjections allowed, but my speaker had to keep speaking louder and louder to be heard. Would you please rule on that? Thank you.
Okay. That is a caution to every one of us. Actually, I was looking for the gestures from the podium itself. So, honorable members, Honorable members, let's respect one another. No, honorable member, don't do that, please. Allow me to bring order. Let's proceed and let's respect each other. Whether you are on the podium or anywhere, you are not allowed to use gestures that are intimidating. Thank you very much. UDM? ATM? Good. NFP?
No declaration.
Thank you. AIC? COPE? PAC?
No declaration, Chair, but we support the bill.
Thank you. Al-Jama?
Thank you very much, Honorable Chair. Honorable Chair, Al-Jama don't support the bill. It was started off as one of the honorable members called it an abortion bill. And we're not going to allow anyone to use bills to further promote abortion. And it is disgusting that members of this House wanted to introduce abortion opportunities to children at a very young age. There are some positive aspects in the bill, but the immoral values trampling on the grave of Chief Albert Tulu who called for fatherhood, that is also disgusting. If the next president is the ANC, they must not go visit his grave because he'll be very upset because of this bill. So Al-Jama's position is that there should be exemptions, especially for Muslim children that are taken out of school for 2 years to memorize the Quran. If we are not going to do that, it affects our faith, our religion. The Nationalist Party, the Apartheid Party gave an exemption that Muslims can go take off a year or 2 or 3, memorize the Quran by heart and come back to school. And those students were some of the best students when grade 12 results were announced. Al-Jama compliments the ACDP for their strong stand on this particular matter in the committee all over. And the nation will be proud of the position of the ACDP on the ballot bill. Thank you very much. We reject this bill.
Thank you. The ANC?
Thank you very much, Honorable Chairperson. And greetings to your good self and all the members in the House. Chairperson, as the African National Congress, we concur with the amendments made by the NCOP. We are witnessing another extensive legislation process that has taken over a decade as basic education sector grappled with multiple issues regarding the amendment of the basic education laws to respond to changing conditions and enhance the existing systems. Transforming our education system from the legacy of colonialism and apartheid Bantu education requires continuous efforts to strengthen the system to address structural and systematic challenges. The bill addresses exclusionary practices that can be discriminatory while protecting the rights of all. Over the past 5 years, we have focused on basic education laws amendment bill and held numerous engagement with the department, resulting in consensus on further amendments before the public participation stage. This is the extent to which the Portfolio Committee prioritized the bill. Appreciating our society's history of education, we undertook an extensive public participation process that involved thousands of South Africans. This includes student organizations, cultural organizations, SGBs, teacher unions, research institutes, NGOs, civil society, religious organizations, citizens, learners, and other stakeholders. The wide range of participation demonstrates the rigor with which the bill was consulted and deliberated on by the Portfolio Committee and the Select Committee of the National Council of Provinces. The process symbolized an activist parliament which is people-centered. we say to the people of South Africa that we heard your voices and have resolved on final bill concurring with the amendments from the National Council of Provinces. The amendments further strengthen the bill to give more clarity in responding to some of the public submissions. We supported all amendments made by the Select Committee as they represented the people's views and strengthened the bill objectives. The Bella Bill has been distorted by various sections in our society who knowingly misinform the public on the object of various clauses in the bill, such as the role of the HOD in relation to the school language and submission policies. The fear created is unwarranted and does not recognize the functions of the HOD. On appeal of the Concord, the Rivonia judgment concluded that the HOD has the power to admit the learner. It held that the school governing body may, in terms of Section Schools Act, determine capacity as part of the admission policy. However, this power is subject to another provision of Schools Act, which states that the department maintains ultimate control over the implementation of the admission decision. Moreover, the court held that the capacity determination set out in the school's admission policy could not inflexibly limit the discretion of the HOD. Further, the Concord in the MLO judgment held the SGB
Honorable Mgweba, please switch off. Apologies for that. Proceed, Honorable.
Thank you, Chairperson. Further, the Constitutional Court in the MLO judgment held the SGB extensive powers and duties do not mean that the HOD is precluded from intervening on reasonable grounds to ensure that schools' admission and language policies pay adequate heed to Section 29, subsection 2 of the Constitution. This is critical to ensure policies are not discriminatory and enable access to children from different backgrounds. This authority can be reviewed through the appeal of the member to the member of the executive, which in provinces is the minister, the MEC for Education. The state has a duty to ensure all children receive a form of schooling, and homeschooling and home education is one form. The bill provision on homeschooling ensures all learners are registered and are schooling. This is it is important that children are protected and ensure adequate schooling support and exist in all corners of the country. We must state that we are dismayed by the false information of the Bella Bill being an abortion bill. When you read Clause 41, member of Al-Jama, please go and read Clause 41 and tell us where do you see abortion there. Please go there. Because now you are supporting something that you don't even have any idea of what is it that is captured in the bill. Can you please make me that favor and go and make sure that you read Clause 41? It is rather disappointing to say the least. We must state that the number of HIV-positive female adolescent girls and young women from the age of 10 to 19 is nearly 4 times more than of boys and young men. And the rate of teenage pregnancy is a concern. This reality requires the department to have provisions that empower the school management and of learner pregnancy cases by empowering the minister with the authority to develop regulations on related matters. Society, the family, guardians, the community, and those social influence should create an environment that enables children and learners to learn and grow in a protected environment, free from distractions. Chairperson, as the ANC, we support this bill, and it is unfortunate that we are here today in Parliament again when we're supposed to be campaigning, because you have created a platform for people that are not in the ground. In fact, they are rejected at the ground level because they are irrelevant. They are still held on to apartheid regime. They are still held on to the laws that prohibited Black people in majority to live the better life that we envisage as the African National Congress. Now, I am requesting, Chairperson, that as the House, we concur and adopt this report
you
with the
very much.
amendments
Your
as they
time
are.
is up.
Thank you very much.
Thank you. Order, honorable members. Are there any objections to the motion as moved by the Chief Whip of the majority party that the bill as amended be passed? The DA?
House Chair, please could we call for a division?
The division having been called, the bells will be rung for 5 minutes. Can I ask those people that are on the virtual platform, don't speak when you are switching on or you are logging in. Check that there is that red arrow on top of your mic on the gadget, please. 5 minutes.
Sorry, I still didn't get that.
Thank you, honorable members. The 5 minutes is up. Honorable members, the speaker has determined that in accordance with the rules and the manual voting procedures will be used for this division. Firstly, in order to establish a quorum, I would request the table to confirm that we have requisite numbers of members physically present in the chamber and on the virtual platform to take this decision. Party whips will then be given an opportunity to confirm the number of their members present and indicate if they vote for or against the question. A member who wishes to abstain or vote against the party vote may also do so by informing the chair. Having confirmed that we have requisite quorum, we will now proceed. The question before the House is that the Basic Education Laws Amendment Bill, as amended, be passed. The voting will now commence.